Hello friends, in the series on the income tax cases, today we will discuss a case which talks about the powers of the Commissioner of Income Tax and the responsibility of the Commissioner of Income Tax in case of appeal filed with the CIT appeal. Generally, it has been seen that in order to dispose of the maximum appeals, because the target given to the CIT appeal is very high, they dismiss the appeal in limine without going into the merit of the case, and they dismiss the appeal for one or the other reason which cannot be the reason for dismissing the appeal. This issue has been taken by Ahmedabad ITAT SMC bench in the case of Brijeshkumar, Jayantibhai Patel versus Income Tax Officer, and this case has been reported in 114 ITR Tribunal Short Notes 1. In the present case, the assessee was a farmer. The assessee has not filed the return of income. A notice under section 148 was issued to the assessee. The assessee didn't responded to the notices under section 148 and subsequent notices under section 142 subsection 1, due to which the assessing officer do not have any option other than to pass a best judgment assessment order under section 144 read with section 147. When the assessee received the assessment order, the assessee filed the appeal before the CIT appeal, and assessee made the submissions before the CIT appeal that the assessee didn't file the income tax return because he do not have any income other than the agriculture income, and for support of the agriculture income the assessee filed various documents along with the affidavits. When this appeal was filed and submissions were made and some additional evidences were submitted before the CIT appeal as per Rule 46A, the Commissioner of Income Tax issued notices to the assessee, but every time the assessee was seeking the adjournments. So the CIT appeal dismissed the appeal in limine by saying that since the assessee is not cooperating, so the appeal is dismissed. But the CIT appeal didn't pass a reasoned and a speaking order on basis of what was available on the file of the CIT appeal. In the present case, the assessee was requesting for the admission of the additional evidences, and the CIT appeal, in spite of taking the views of the assessing officer on the admissibility of those additional evidences, or without taking the ground of the assessee that whether these additional evidences should be accepted or not, the CIT appeal dismissed the appeal in limine. So when this matter was carried to the tribunal was of the considered view in the present case was that in the present case the CIT appeal ought to have called the assessment records. The CIT appeal should have made proper inquiries either from the assessee or through the assessing officer. The tribunal said that in the present case, it was the duty of the CIT appeal to either summon the assessee or summon the other parties through which the assessee can, through which the CIT appeal can verify the truthfulness of the affidavits and the evidences submitted by the assessee. And since the CIT appeal has passed a non-speaking and non-reasoned order, and whatever the order has been passed by the CIT appeal, that order is not as per the mandate of section 250 subsection 6, because section 250 subsection 6 says that the CIT appeal has to pass a reasoned order. So in the present case, on the facts and circumstances of the case, the tribunal remanded this matter back to the CIT appeal and pass a fresh order and a reasoned order by giving proper opportunity to both the parties, that is the department and the assessee, and then pass a reasoned order. Friends, although in the present case the assessee was taking unnecessary adjournments or the assessee was non-cooperative at the time of the assessment also, but there are sufficient safeguards for the assessee in the Income Tax Act itself that even if being so unresponsive, this matter was again remanded back to the CIT appeal because the CIT appeal has not followed up the mandate of section 250 subsection 6, and he was directed to pass a reasoned order as per section 250 subsection 6 on the basis of whatever the evidences was available on his file. At the end of this video, once again, I am repeating the name of the case. The name of the case is Brijeshkumar Jayantibhai Patel versus Income Tax Officer, and this case has been reported in 114 ITR Tribunal, short notes 1. The date of the judgment is 15th July 2024. Thank you, friends.